what can people do if they are being denied a claim or if they are being denied coverage? Because a lot of times it is a bureaucratic navigational problem to reach out, and you call the hotline, then you speak to this person, they give you to the next department. And are there remedies for people? Like, what can they do if their claims are being denied that you see?
So I'll give you an example of somebody I'm working with today.
Yeah.
This person is the father of a 22-year-old who has mental health issues, and Dad has self-funded thus far about $300,000 in services. And he has contacted me because he is furious and frustrated at the endless number of phone calls, and you go through endless telephone prompts when you call the health insurance company. He spends hours just to get to a human being. And then he finds that the claim is lost, or the claim they can't identify it because no claim number has been assigned to it. So what I tell him is, in order to analyze these sorts of claims, first of all, everything springs from, we know it as the insurance policy. It's technically called the certificate of coverage, mm-hmm. but it's the big document that you get that defines your rights and your obligations and the health insurance company's rights and obligations, and everything starts there. And because it's typically a 40 or 50-page document, I used to work with a guy, the best commercial lawyer I ever worked with, bar none. And he used to say, if you've got a 50-page contract, you can always find something. And he's right. That's one of the weaknesses of the English language. There's always going to be a place that an advocate can grab onto and say, applying this language, you're entitled to coverage. So for this fellow, this father, I'm starting with the certificate of coverage, and then I'm working through what the appeals say, his appeals and their denials. And I expect that I will present to him a proposal for litigation. He doesn't have to accept it. These cases tend to be really emotionally tough for patients and patients' families, because it's such a personal thing, and the personal thing relates to the illness of either the plaintiff himself or the family member. But he's talking about a lot of money, and he wants help. His view is, I pay an insurance premium. That buys me something, and it should buy me insurance coverage. So what I'm trying to do is to work with people at the sort of the commencement of their conversation with the health insurance companies, to help guide them through that. This is pre-litigation. This is even before anybody's really contemplating litigation. The idea is hopefully litigation isn't necessary if you can get an insurance company to cover enough. And the truth is that a lawyer, and it doesn't have to be me, but a lawyer is better equipped to present these arguments to a health insurance company than a layperson.
Let me stop you though. What I guess my concern is, and this is, again, we have buckets of different people that are your potential clients. You're right. Talking about a person who's spent out of pocket $300,000, and you're talking about putting together a litigation proposal to this person. It sounds like, and maybe I'm wrong, he has the ability to pay a lawyer, a high-powered lawyer like yourself, to get him through that process, and he's willing to spare no expense. Screw them. I've been paying premiums. I've lost $300,000 because they're not reimbursing for all these different claims. I'm willing now to pay you whatever your hourly rate is or whatever your retainer is for you to do this, right? Because he is in a position to do it. What about the average person? How does the average person, because that's where I think this uprising is, where you have an insurance company that is all powerful, that are denying claims. They feel that these claims should be being paid, and they can't come to you and say, I'm going to pay $500 an hour or $600 an hour. They don't have the money. No one does.
Well,
how does that person get, I guess, redemption, or how do they get justice if their claims are being denied?
I don't do coverage cases except on a contingency. This guy could pay. I have an hourly rate that's been approved by a judge that is that makes my eyes bleed. I couldn't pay it, mm-hmm. But I'm not going to ask him for that, and he probably could pay it, but that's not my deal with any of these insureds. I only charge on a contingency. To work it up, in some circumstances, I may ask for a small sort of a retainer. Uh-huh. But beyond that, if we get to litigation, it will be a contingency.
And again, I'm interrupting you because I'm just trying to understand it. This individual he's out of pocket $300,000, and he believes he should be reimbursed that $300,000. So, lawyer like you gets involved working on a contingency. You're kind of capped at getting back the $300,000, right. And you take a percentage. You take $100,000, he gets $200,000. He's happy because he got some of his money back. You got paid for your work. You went and you did your job.
Right.
But when we talk about even smaller, when we talk about these smaller cases, and I know there are lawyers that do healthcare stuff, and maybe you do this stuff, but how is it that are there attorney's fees provisions that are in these contracts? Are there statutes that allow for attorney's fees so that the average person, they're getting screwed? Their family member was diagnosed with cancer. The insurance carrier is not paying what they should be paying. The family is not able to get the treatment that this person needs. Is there a lawyer that they can hire that they don't have to fork over money in that situation?
The answer is yes. So I told you that ERISA regulates 65 to 70% of all the healthcare plans. And ERISA, as a statute, mostly favors insurance companies, except when it comes to fees. ERISA has a built-in attorney's fees, prevailing plaintiff attorney's fees provision, so that if a plaintiff wins under the statute, the plaintiff should be able to recover his or her fees. And the fees don't have to somehow connect with the value of the claim. I had a case in federal court in Milwaukee, and the claim ended up being smaller than I thought it was when I started. The claim ended up being a $25,000 claim. Mm-hmm. And I ended up having $100,000 plus in fees, and the judge awarded everything. The judge granted the $25,000 to the plaintiff. I think he knocked my fees down a little bit. But my fees were multiple times what the individual recovery was. And the statute sort of contemplates that, because by having this prevailing plaintiff provision in ERISA, the statute recognizes that sometimes you get a dispute over a small number, and if there isn't that sort of provision where a lawyer can capture his fees, that plaintiff is never going to be able to get to court. Nobody's going to take a $25,000 case on a contingency. That can't happen.
Yeah, and it sounds like just from what you're telling me is ERISA. If a health insurance policy is governed by ERISA and the insurance carrier is denying these claims, the ERISA statute is giving an incentive to that insurance company. Hey, you pay, or else this person can hire a lawyer, and they won't have to pay out of pocket for that lawyer. That lawyer will jump in, go after the health insurance company. They will get the client paid. They will get the client's health insurance claim paid, and then their attorney's fees are going to be paid. The client doesn't have to pay it out of their pocket.
Well, you need a judge to agree with that.
You get the judge ultimately,
right?
Or it could be settled. I mean, I guess there is always the possibility you hire a lawyer to go after the health insurance company. The health insurance company makes the decision, we should have paid this. They pay it, and there's an agreement. We won't sue in exchange for paying for the claim and the attorney's fees.
So ERISA does not permit the recovery of extra contractual damages like pain and suffering or punitive damages. But the flip side is that it specifically permits the recovery of fees. And that can be a powerful incentive for a health insurance company when its coverage decision is challenged to pay, because they know that lawyers like me, even a small claim, even a $25,000 claim ends up being a lot of work. A $25,000 claim or a $300,000 claim, generally the amount of work is the same. You've got the same sort of issues and the same sort of briefing. ERISA does not have specifically does not permit jury trials. So what that means is that usually the ERISA cases are decided on motion. If they're not decided on motion, then you have a trial with a judge. And most judges will say, yeah, we'll figure it out on a motion. I don't want to take the time. The attorney's fee provision is one of the few statutory incentives that ERISA provides to get a health insurance company to, if a coverage is iffy, to pay the claim.
Yeah. See, what people need to realize, and it's slowly happening, like it happened here in Florida, where the legislature, the lawmakers have been passing these laws that are now eroding. It's taking away the ability of the normal person who doesn't have all this money to pay a lawyer to sue insurance companies. We got property damage law has changed dramatically in Florida. Personal injury protection law has changed dramatically, where it used to be if your roof got blown away by a hurricane, you could hire a lawyer. If the insurance company's not going to replace that roof, hire that lawyer, sue the insurance company. The insurance company, if they should have paid, they fix the roof and they pay your lawyer. And now the law has changed where you can sue that insurance company, but the insurance company can fix the roof and there's no responsibility to pay the lawyer. You're going to have to pay part of what it costs to get that roof replaced as a fee to the lawyer. And what people don't understand is that those kind of tort reform laws impact them the worst.
Right.
Impact them the worst. Like at least you have, ERISA has this fee provision that allows you on a claim, let's say the ERISA policy didn't pay for this chemotherapy treatment that is going to cost $30,000, $40,000, whatever that therapy is. They can hire you, get it paid, and then your attorney's fees are paid. And sometimes if that insurance company doesn't want to make a good decision, they're going to have to pay a lot more than $30,000 to you to fight them to make them pay ultimately.